Welcome to Knowledgeable Aging. I'm your host, Jason Kotar. Joining us today to talk about probate part 2 of 2 is Lindsey Sarowitz. Lindsey has been with Handler Levine since 2013. She's an associate with the firm and regularly represents individuals, including federal government employees, in preparing their estate plans, consisting of wills, trusts, powers of attorney, healthcare directives, and other estate planning documents. She also represents estates and trustees in regard to decedents issues, helping guide families through probate and trust administration following the loss of a loved one. Ms. Sarowitz is a member of the bar in Maryland, Virginia, and the District of Columbia. How are you doing today, Lindsey?
I'm good. How are you?
Very good. Thank you for joining me for part 2 of 2 on probate. Before we get started, for those that are joining us for the live webinar, if you have any questions, type your questions in. Time permitting, we will do everything in our power to get your questions answered. So Lindsey, during our last webinar, part 1 of probate, we talked about probate. We went over a lot, such as what probate is, what probate assets are, some of the requirements of probate generally, as well as how to pick the right person as a personal representative or executor in your will. Can you just briefly refresh us before we get to part 2?
Sure. And I may have mentioned when we talked last time that I do a whole 4-hour course on probate in and of itself. So like you said, I'm happy to answer additional questions. I could talk about this for at least 4 hours, if not more. But just to refresh briefly, kind of what we talked about last time and some important topics just when talking about probate generally. So what is probate, right? Probate is the court supervised process that identifies what probate assets a decedent held at their death and oversees distribution of those assets, whether that's according to the person's last will and testament, or if they died without a will, that's called dying intestate, and then distribution is according to the state statute. So in that, right, I just mentioned probate assets. So you can't figure out probate unless you know probate assets. So probate assets are assets owned by the decedent alone, meaning not assets held joint with rights of survivorship. That's like that asset that we talked about, you know, if you and your spouse own your home together, then at your death, it just goes to your spouse and vice versa. Well, whatever you own without your spouse, you know, and then also without beneficiary designation. So your 401ks, for example, your IRAs, your life insurance, those all have beneficiary designations. If you don't have them filled out, please do so for everyone on the call. But so those would not be probate assets, whereas like your bank account, stuff like that would be, unless of course you have a payable on death or transfer on death designation. So that's kind of what probate is and what probate assets are. Now, last time we also talked generally about the probate process, which, as we discussed, it does vary somewhat dramatically from jurisdiction to jurisdiction, of course, depending on what the jurisdictions are, right? But generally speaking, it's always going to start with filing some sort of petition for probate by the appropriate person. So the appropriate person is that person that you've named in your will, or if you don't have a will, the person that the law has stated, you know, is the right person for the job, right? There's an order of priority under the law in your jurisdiction. And you also have to file the original last will and testament if there is one. It's important, I think it's important to note that if your people, whoever you leave behind, can't find your original will, there is a presumption that you destroyed it and therefore revoked it during your lifetime. So that's just a good little tidbit to keep in mind to emphasize how important it is to keep your will in a safe place. There would also be some sort of proof of death filed, you know, showing that the person's actually passed away. That's typically done through the death certificate. It could sometimes be an obituary. And then you submit, you know, certain information about the legatees. Those are the people entitled to inherit under your will if there is one. The heirs, those are the people entitled to inherit from you under the law if you don't have a will. And the person that you've named or that is asking to be named as personal representative. So those are kind of some, but you know, some aspects of probate that I think are important to recognize and kind of refresh on. Now, We did also talk about how to name a personal representative, I think, and we discussed kind of characteristics to look for when deciding on a personal representative, because a lot of times clients say to me, like, how can I pick my PR, my executor, right? And they say, I have 2 adult kids, but can't you just do it? It's easier to just choose you. And, you know, while that's a tremendous compliment, of course, I generally say the professional, right? The person who is going to get paid, right? The attorney, the CPA, the trust company, should be the end of the analysis. Before looking to a professional, you should certainly think about who's in your sphere, who in your family, if not your immediate family, expand the definition of family. Think about more distant relatives, maybe close friends, colleagues you've worked with for a number of years, because yes, they are entitled to charge for their work. Oftentimes they don't. And even when they do, they usually charge less than the attorney, for instance, right? We don't come cheap. So the 2 characteristics we say to look for are trust, right? You have to trust the person. You're giving them access to an awful lot of assets and information, and common sense, right? They don't have to have any specialized ability. They can hire an attorney to help with the legal stuff, a CPA, an financial advisor. Oftentimes they should hire professionals and use your money, right? They're not going to come out of pocket, but they have to have the common sense to recognize when they need to do that. Does that make sense? Ring any bells? I don't know. It's a lot.
No, it does.
Yeah, those are just some things that we kind of talked about last time, I think, and that I think are worth refreshing for both of our sakes today.
Absolutely. Well, so let's say someone passes away. How does the family begin the probate process?
So I think that that's a really important question. In fact, today I just got off the phone a little while ago with a client whose husband just passed away last week. She's been a client of ours for a while. We actually just finished up her mother's estate administration, and her husband just passed last week. So she kind of knows, right? She knows that something needs to be done. She said to me, Lindsey, I haven't gotten the death certificate yet. What should I do? And I was like, you know, that's okay, right? He just passed away. I don't know about other jurisdictions, but certainly here. So I'm in Maryland, as you said. I practice in Maryland, DC, and Virginia, and they are still experiencing, or we are still experiencing delays with regard to receiving death certificates because of COVID and things like that. So that's all right. You know, there's no time requirement, at least locally, and probably not in other jurisdictions, although I can't say for sure, you know, that say you must probate the will within 15 days or 30 days of the passing, right? But so in every jurisdiction, like I kind of said already, there's going to be some sort of petition for probate that's going to outline the specifics about the individual who passed away, the person who's asking to be personal representative. It's important to note that just because you're named in someone's will doesn't mean that at the time of their passing, you are the personal representative. Rather, it means that they have elected you to be appointed by the court as personal representative. So there are other things that could get in the way of your appointment, such as if you're convicted of killing that individual, right? That's going to eliminate you from being able to serve. Certainly, hopefully no one on this call today is going to be, oh man, I guess I can't do the job then. But, you know, other things too, right? You need to be able to be bonded, certain things like that. You can't be convicted, at least here, of a crime that affects your ability to handle money, let's say. So like embezzlement, forgery, extortion, things like that. And that makes sense, right? Because you're going to be handling a lot of money for someone else. So those are just a few things, but it's that connection should be made that you're appointed by the court right? So even if you're named in the will. So the person nominated as personal representative in that will is going to file the petition, the proof of death, those sorts of things. The original will, like I said, if that can't be located, there's a presumption that it has been destroyed and revoked. And then there's typically some sort of bond that needs to be acquired, notices that need to go out to, you know, here it needs to be published in a newspaper of general circulation, and things like that in order to get the probate process started. And then depending on where you live, or I should say where the decedent lived, that will determine where the probate is going to take place, and where it takes place is going to determine what follow-up filings are required, right? So accountings, inventories, things like that, that need to be filed after the person is appointed by the court.
So Lindsey, you had mentioned that obviously jurisdiction to jurisdiction, the process is different. You're in DC, Maryland, and Virginia, so maybe you can just speak just to these three jurisdictions, but how has the pandemic impacted the probate process?
That's a really good question. It has impacted us. So in the beginning, right, when the pandemic first started, and people were really working from home and the courts had closed, in the beginning, it was a lot of, what do we do, right? So they had to figure out, and it was a matter of first impression, right? This hadn't happened before. So the probate courts, here we call them the Register of Wills, had to figure out, how do we get these filings even filed, right? We used to send them to a place. Well, now there's no one at that place. So from start to finish, they really had to go through and revamp their entire process. As the pandemic moved on, right, and people were figuring out how to work, you know, I know in Montgomery County, where I'm physically located, they were working from home certain days, working from the office other days, operating in a team schedule so that the two teams weren't there at the same time in case there was exposure. And they really did so in a pretty seamless way, I would say. But again, the different jurisdictions have varied drastically even with that. In DC, even currently, there's a very significant time delay between when we're petitioning the court, sending in the documents as the court has directed us to do so, and the timing when our clients are being appointed as personal representative. So that needs to be considered, because I don't want people to think that it's a quick, you know, you're going to get access to the money right away. Now in Montgomery County, it has been very quick. In fact, I filed documents last Wednesday, and today we got the documents saying that my client's been appointed. So that's pretty quick turnaround time. In DC, in the beginning of the pandemic, or during the pandemic, I had filed documents in October of 2020, and my client didn't get appointed until April 2021. So I can't say exactly how long it is in DC now, but that was kind of, you know, that's a big difference.
So what do you tell somebody then, as the pandemic, you know, we were kind of in and out, and we're still going through this. So when somebody calls you, what do you tell them now with, you know, the new variant being out there now? And I guess, you know, not sure if maybe some government offices may be closing. I mean, it feels like we're kind of up in the air.
I agree. We're very much up in the air here in Montgomery County. As of Saturday, they've mandated masks again. And so I don't know what the court is doing, right? I'm hoping to get some guidance, you know, maybe tomorrow about what their plan is. They were opened, at least for appointments, I believe, to the general public, right? So you couldn't just walk in like you used to be able to. I haven't gone there in over a year. I just send my stuff by a courier. But I don't know if they're going to go back to the way it was, operating on different teams, right? They just got back to doing things somewhat normally. And DC too. DC just went back, I think, like 2 weeks ago or something. So that's pretty recent. So I'm not really sure what's going on there, but I just try to lay the expectation, or the fact that I don't really know what the expectation should be, right, from the outset. I really don't want anyone to think it's going to be a very quick thing when I, quite frankly, don't really know. So we have to work through things, right? So if there's creditors, you know, maybe we have to explain things, right? Maybe we have to explain to the creditor, or right now I'm dealing with a case where there's a reverse mortgage. I've had to get extensions for that case because the reverse mortgage company understands, right? But if we didn't tell them, they wouldn't know that in that case, there's a COVID extension. So fortunately, a lot of the companies by now are set up in a manner where they're pretty understanding, but we need to make sure we take that step to inform them at least.
Yeah. So where does this information and documentation get filed, Lindsey?
So the information needs to get filed with the probate court, or here we call it the Register of Wills office, in the jurisdiction where the decedent was domiciled at their death. So domicile, a simple way to define it is residence plus an intent to remain. So if you're a Maryland resident living in Montgomery County, but you're traveling in Florida, for instance, and you pass away, the probate's going to occur in Montgomery County, not in Florida. So that's easy. But conversations come up when someone is moved for care, right? Especially in jurisdictions where, you know, people move around from jurisdiction to jurisdiction a lot. Like here, Maryland, DC, Virginia, you know, they're pretty people move around here a lot. So moving for care, let's say mom has advanced Alzheimer's and son moves her from Maryland to Virginia so she can be in a home closer to him so he can visit her more often, right? That happens a lot. And I would say if she then passes away in Virginia, well, she didn't have the mental capacity, the ability to form the intent to change her domicile to Virginia. So I would argue that her domicile was still here in Maryland. Rarely do I actually have that situation, but I'm ready for it if I do, to make that argument. And I do think that's an interesting conversation. But otherwise, you know, it's the jurisdiction where the decedent was domiciled at their death. And then it's also important to know that if the decedent owned real estate in multiple jurisdictions, then there has to be what's called an ancillary probate in those additional jurisdictions that they owned real estate.
So would the individual then have to find an attorney licensed in that state where that real estate is being held?
Yeah, so typically what the attorney that they're working with should be able to do, like for instance, if I'm helping a client with a probate here, wherever here is, right, Maryland, DC, or Virginia, and say mom had a winter home in Florida, we have that a lot. Generally, what I would, you know, say to the client, of course, they're welcome to find their own attorney down in Florida. I happen to have connections down there. I happen to have worked with multiple attorneys down there. So rather than them just going out and trying to find someone, I'm happy to make that connection and actually facilitate that probate down in Florida, because again, it's what we call an ancillary probate. So the probate procedure is shortened and it's much less than it would be if it was the primary probate. Now, how complex and everything the ancillary administration is totally depends on that additional jurisdiction. But usually, certainly if the client wants, we'll start that process for them at least.
Okay. So you had mentioned personal representative earlier, Lindsey. I'd like to shift to that now. So what if a person is named to act as a personal representative but does not want to take on the job? Do they have to?
So that's something that a lot of my clients don't consider, and I urge them to, because the answer is no. If you name someone, if you say, I'm going to name my brother because all he put me through as a child, he owes this to me, it's going to be like a gotcha if I pass away. So sorry, but the joke might be on you, right? I mean, just to add a little levity to this subject, but if the person is not willing to act, even if they told you years ago when you wrote your will that they would act, there's no legal requirement that they say, yes, I will be your personal representative at the time you pass away. That's one of the multiple reasons that I always suggest having backups, right? You don't know if the person you've named is going to be in the car with you or predecease you and you forget to update your will, or whatever the situation may be. So I've never had a situation where a client's named too many backups. In fact, if someone has 4 different people they're perfectly happy naming, you know, one, then the other, then the other, then the other, for me, it's just words on a piece of paper, right? A little extra ink, maybe an extra sheet of paper. For them, it could make all the difference, right? We don't want to get too crazy with it, but the person who's named does not have to act for you. Of course, once they do take on that role, right, once they do file the petition for probate and they're appointed by the court, they do have the fiduciary responsibility to act reasonably in the role. And if they are no longer able to act, they will have to, you know, reasonably find someone else and kind of bow out, and the documents should allow them to do so.
How often should the individual have the conversation with these personal representatives about the process and their involvement?
Sure. So, well, I tell my clients to look at their documents every 2 or 3 years, make sure they still make sense to them. Sit down with me and have like a checkup every 5 years or so.
Okay.
So I think that a similar concept would make sense for the person you've named in any of these roles, right? Kind of check in. I'd say one really important thing is to make sure, so if you're named in someone else's will, let's say, the biggest piece of advice I could probably give you is make sure that you know where their stuff is, right? If they pass away, do not expect to be able to call an attorney and say, hi, I mean, I've gotten this call. I don't know where my brother had his accounts, but can't you just find them? And no, there's no magic, right? We're attorneys, we have certain capabilities, but there's no place we can look up where anyone in the world, you know, has accounts. So if nothing else, just make sure that they leave you some sort of list or something. If they're not comfortable leaving the account numbers and passwords and stuff, that's okay. Just have them write down, you know, I have an investment account at Fidelity, I have life insurance with so-and-so, you know, go through bank accounts, every asset that they have, credit cards, you know, liabilities, so assets and liabilities, just some sort of direction, because otherwise, you know, you never want your assets to go to unclaimed property or anything like that. Just let your people know where they are. And again, if today you're not comfortable telling them, just tell them where that piece of paper is located.
Are there any pre-probate duties that are required for this personal representative?
Pre-probate duties. So you mean while the decedent is still alive, so they're not deceased? Not duties, no. But again, I think that the biggest piece of advice is, hey buddy, whoever's named me as their personal representative, let's sit down. Let's make sure you've left me this list somewhere. Tell me where it is. If you don't want to give it to me now, that's okay. Tell me where it is. Tell me who your advisors are, right? People who know the information. Who's your CPA, the person you've been working with for 30 years to do your tax returns? Most likely is the best person, most efficient person to be doing the tax return after you pass away too. So one thing that I give out to my clients, I don't know if I've ever provided this to you, Jason, but I'm happy to email it to you if I haven't. I just created this letter of instructions, right? It's not really a letter at all. It's not a legal document. It's about 15 pages worth of questions. And the client, I just give it to all my clients and I say, you know, do yourself a favor, fill this out for the people you leave behind. Or if you don't use my form, that's fine. Write it on a loose leaf paper for all I care. But it's just, you know, leave them instructions, leave them direction, tell them where your accounts are, who your people are that you want notified if something happens to you. You know, even things like the person you've named to act for you might not know where you went to school or might not know all these things that maybe it's important to you that they write in your obituary, for instance, right? So things like that that aren't legal things, but that would be helpful for them to know, you know, write it down. I know that they sell books on Amazon. So there's one called Dead, Now What? My mom bought that one. And then she also bought one called I'm Sorry for Your Loss, It's Me. She didn't fill them out at all, right? So like buying these books and not filling them out, that's another issue. Getting the form that I've created for my clients just as a helpful resource and not filling out similarly is not helpful. So just sit down with it. It's horrible to think about, but just leave behind whatever information you think might be useful, recognizing this piece of loose leaf, right? Or the binder of statements from your investment accounts or your old tax returns, whatever it is that you leave behind. Remember, that is not a legal document, right? Please, no one listening to this, do not misinterpret me to be saying, oh, just write it down and that's fine. That's your will. That's your power of attorney. It's not, right? You need to execute the estate planning documents still in accordance with the law. But this is just a helpful additional document.
Yeah. So you had mentioned that, I believe on the first webinar, Lindsey, you had said that you can remove or add personal representatives. Can the court remove a personal representative?
They can. You never want to be in that position, but if a personal representative is acting inappropriately, right? Someone is managing your money in an inappropriate way. There's suspicion of wrongdoing, something like that. Let's say you've named your sibling to administer the estate and your adult children are the beneficiaries and they think something wrong is going on. Yes, they can petition the court for removal of the personal representative, and there will be a hearing. You know, a judge is going to ask the personal representative what's going on. You know, are the kids just being a problem? Or is there really money missing or a reason for someone else to be appointed? So the court certainly does have that jurisdiction and that ability. And that is one of the upsides and I guess one of the downsides of having probate, right? There's the court oversight that some people like because of that thing that we just talked about, right? The court can oversee and remove inappropriate actors. Some people don't like the court having that ability. Some people want to go a different route and avoid probate because probate is public. And, you know, there is that court oversight. So it depends on which side of the coin you fall.
Last question about the personal representative. So once the probate process has started, is there any compensation for a personal representative?
So yes, the personal representative is entitled to compensation. This is another one of those things that differs from jurisdiction to jurisdiction, what the allowable compensation is. So some jurisdictions say reasonable compensation and don't give much guidance beyond that. In Maryland, a personal representative is entitled to reasonable compensation, but there's a calculation that is the statutory maximum that the personal representative and the attorney, if there is one, that they can get combined. That being said, sometimes that statutory maximum is too much, right? If there's a really simple, really large estate, then the personal representative should not be getting this huge amount for only doing a little work. On the flip side, if it's a very complicated estate that's not that big monetarily speaking, the statutory maximum is really not enough to compensate the personal representative. So in a case like either of those, well, not the first one, but the second case, the personal representative or the attorney, if there is one, can petition the court to get more than the statutory allowance. So that's why I put statutory maximum in quotes, because yes, it's a maximum, but it's a reasonableness standard. It's unreasonable if there's a litigation and a very complicated situation and it's a $500,000 estate, you know, it's unreasonable for them to only get, say, $10,000, I'm just making this number up, $10,000 worth of commissions. Whereas if it's a $10 million estate, everyone gets along, it's real simple, you know, the statutory maximum is way too much.
Yeah. So obviously there's a lot that goes into probate. You had mentioned this is what, a 4-hour course that you teach?
I do.
Wow. So let's just say I'm named as a personal representative of somebody's will and they pass away. Do you have any, I know you covered a lot. Do you have any, maybe a couple of nuggets as takeaways for our audience?
I do. I have a couple for sure. One is with regard to creditors' claims. So one thing that comes as a relief to a lot of people is knowing that you cannot inherit debt. Now, I always say this, but I want to say last week I was talking to a financial advisor in Virginia who notified me that there's some law change that I don't know about yet that deals specifically with Medicaid. Okay, so I'm not dealing with that when I say this because I don't even, being honest, I don't know about that law yet. But with that exception, you cannot inherit someone else's debt. Now, if your parents, for instance, leave a whole lot of debt and not a whole lot of assets, you're not going to inherit anything, but you're not going to be liable for their unpaid, you know, cable bill and, you know, things like that, even doctor bills, things like that. So you're not going to inherit debt. But if there is a situation when there are creditor claims or potential for creditors to be claiming money, it's really important to understand the claims laws in the jurisdiction where the probate is occurring, because some places, like in Maryland, it's a very decedent friendly state, I would say. So the creditors need to come forward within 6 months after the date of death and file a claim or notify the personal representative that something's owed. Otherwise, they're kind of out of luck. Now, in Virginia, it's very, very, very different. You have to go out and actually seek people that may be owed money. You have to ask for what's called a debts and demands hearing with the court. That deadline is much longer. So what I would say, even if you're not planning on having an attorney assist you, because there's no requirement that you have an attorney assist you with a probate, if you are named, if someone passes away and you're named as personal representative, just pay for an hour of an attorney's time and have them, you know, explain to you and go over with you the creditor claims rules in that jurisdiction. That is probably my biggest piece of advice, aside from that other piece that I said, have your loved ones write down where their assets and debts are.
Okay, we have one last question, Lindsey. It says, can the appointment by the court, letters testamentary, include a section that gives the personal representative the appointment and ability to handle digital and tangible assets?
So we have, in the last few years, when it comes to digital assets, we've had a lot of additions to our documents, right? So when it comes to like our powers of attorney, that's the document that takes over if the person's incapacitated typically and unable to handle their finances, but still alive, right? So we give them the ability to handle digital assets. Now, when you are appointed as personal representative, and the court issues the letters testamentary, like that person called it, or letters of administration, that's what it's called here in Maryland. No, there's not a separate separate place where they're able to handle those assets, but rather it would be that same document, that same letter of administration, letters testamentary, that you would submit to that company wherever you're trying to handle the digital assets. And that should, I say should because it should, be adequate. Now, if a company is giving you a hard time, then they might say, no, we require a court order or something like that. But hopefully no one has that come up, because again, the letters of administration, that's the document that you take wherever the decedent had assets. You don't have a separate one for Bank of America and another one for Fidelity and a different one for, Bitcoin, right? You take that same letter of administration everywhere where the decedent held assets, and that's what gives you access.
Very good. Well, Lindsey, how can people find you?
Oh, thanks for asking. People can find me. Our website is www.handlerlevine.com. That's HANDLERLEVINE.com. My name is Lindsey Sarowitz. So my email address is Lindsey, LINDSEY, at, again, handlerlevine.com. My phone number is 301-961-6464, and I'm at extension 3315. I'm physically located in Bethesda, right by the metro station, so pretty convenient location. And I'm happy to answer any follow-up questions people have. They can just shoot me an email.
Very good. Well, thank you again, Lindsey. As far as knowledgeable aging, you can go to our website, knowledgeableaging.com, and you can see all of our upcoming and archive webinars. We encourage you to go to YouTube. You can type in knowledgeable aging. We also ask that you do subscribe. We update that as much as we can. Also, if podcasts are your thing, you can find us on Apple, Tunes, Spotify, etc. Till next time, I'm your host, Jason Kotar, and this is Knowledgeable Aging.